Well, welcome, everybody. I think we're going to get started now. And you all know what the topic is. The topic is what are the priorities and policies looking into the future of the Department of Justice. Each one of our panelists is a former member of the Department of Justice in various iterations. And I saw Bob Bork Jr. here, and it reminded me of something that Judge Bork used to say when he was talking about the Department of Justice. And he was acting Attorney General for a time during the Watergate period. And he said that outside of the Attorney General's office, there is a saying that written, and it says that the government prevails when justice is done. And Bob used to say, but it's written in the round. You have to think about that. Anyway, our first speaker, I'm going to introduce each speaker together in one fell swoop. Our first speaker is John Richter. He's a partner at King & Spalding. And his experience at the Department of Justice was as Principal Deputy Attorney General, Chief of Staff, and Acting Assistant Attorney General in the Criminal Division. Our next speaker is Lee Casey. He's a partner at Baker & Hostetler. And from 1986 to 1993, he served in the Department of Justice Office of Legal Policy and then in the Office of Legal Counsel. And he was also a Deputy Assistant General Counsel of the Department of Energy. He's written many books, book chapters, and articles. Our next speaker will be George Terwilliger. He's a partner at McGuireWoods. He spent 15 years in the Department of Justice as a prosecutor, as Deputy Attorney General, and as Acting Attorney General during the George H.W. Bush administration. Scott Keller is our final speaker. He's a partner at Baker Botts. He's a former Solicitor General of Texas. He clerked for Justice Kennedy and was a Bristow Fellow in the Department of Justice Solicitor General's office. John?
Well, good afternoon, everyone. We're going to talk about the Department of Justice today, and I'm sure that everyone is focused here in Washington, D.C. on the thousands of men and women doing cases all across the country. Very interested in what the department is doing in combating violent crime and drug trafficking and immigration issues. I'm sure they're very concerned about the department's civil, affirmative, and defensive docket. So at the risk of ignoring the proverbial elephant in the room, I'm going to talk a little bit about that and talk about, I think, some broad themes that are worthy of consideration by the Department of Justice at any time and the leadership of the department. And obviously, as the leadership is again in transition, it's a time when remembering certain first principles is an important thing to do. What's interesting, of course, as we know, I'm going to speak really and focus primarily on the criminal side of the house at the department. The scope of federal criminal law, as I'm sure everybody here recognizes, has exploded in the past few decades. I know there was a rough estimate done by the Heritage Foundation that there are more than 5,000 federal criminal statutes and more than 300,000 federal regulations that contain criminal penalties. And from time to time, that's certainly been labeled as overcriminalization. That's certainly a topic of much discussion. And commensurate with the growth in the statutory scheme has come, obviously, the growth in the department itself and the lawyers at the department. If you really think about the historical numbers of the Department of Justice, of course, we know that at our founding, there was no Department of Justice. You just had an Attorney General. But in more recent history, since 1970, in 1970, there were about 33,000 employees. And, as of at least today, we're well over 115,000 employees. And in terms of prosecutors, you could even see the growth in the very near term. So during my tenure at Justice, as in leadership positions, both as in the criminal division and as the United States Attorney. The criminal division had about 450 lawyers. The U.S. Attorney community had about 4,500 lawyers. And we are now in a place where the criminal division has 575. During my tenure, there was no National Security Division. That got split out. The National Security Division has about 231 lawyers, so the combination really now is really over 800 lawyers. And then you've got about 5,500 AUSAs around the country. And commensurate with that then is also then the explosion of major firms with white-collar and government investigation practices. And I'm deeply grateful for that personally, but and so, as I always say, some of my personal beliefs run counter to my own practice. But obviously, these kinds of government investigations practices would only exist and only occupy a central part of major law firms if you didn't have this kind of growth. So in terms of pinpointing exact causes of overcriminalization, obviously critics and analysts point to a lot of things. Certainly it's attributable to Congress's willingness to pass ever more statutes and use federal criminal penalties to tackle various policy concerns and issues that it perceives. And of course, you've got the growth of the administrative and regulatory state and the corresponding increase of duly promulgated regulations that impose criminal penalties for misconduct. And those obviously present significant and many times legitimate political and constitutional questions about the proper purposes of federal criminal law, about the roles and relative responsibilities of the federal government and the states in policing individual conduct. And so they're very important. But I'm going to focus instead on what I think is more controllable for leadership in the Department of Justice. They're not going to be able to roll back very many duly promulgated statutes, particularly if they're regulations and statutes. And so I really want to focus on a phenomenon that in some ways is more concerning, and that's the ever-growing trend of regulation through enforcement. And that's the practice of using essentially administrative enforcement actions and criminal prosecutions to advance and cement theories of criminal liability that are not expressed in statutes or duly promulgated regulations, or to police certain conduct. I was at a conference yesterday with a number of fine career federal prosecutors. We were talking about the anti-kickback statute, and I was complaining about its breadth and therefore the discretion that it essentially leads to apply to a lot of different conduct, and the lack of obviously notice therefore given to the folks who operate in the healthcare space where the anti-kickback statute applies. And during the remarks, I was struck by the fact that this career prosecutor, who I think is exceptionally talented, well-meaning, and a good prosecutor, expressed the view that, well, you know, what we really look for when we're enforcing the anti-kickback statute is whether the conduct in question distorts the marketplace. So my reaction, of course, at the time was, well, AUSAs are not economists, and frankly, economists aren't that good at figuring out what the marketplace. So, and it's nowhere written in the law, but I think it does illustrate, I think, some of the attitude and norms that inhabit, good career prosecutors who are well-meaning, who are trying to do their jobs, but nonetheless may have lost sight of the proper role of the institution. And so, when, at a high level, when the federal enforcement attorneys bring a criminal action against a defendant that advances a novel or expansive theory, what it does is basically allow the government to use its significant leverage, both the monetary penalties, the potential for debarment for companies, imprisonment for individuals, oftentimes to secure resolutions and pleas that essentially establish a new norm or an informal precedent that can then be pointed to across an industry or across a swath of our society to say that's the new line, even if the statute or the regulation is far from clear that it may really cover it, and no court has actually sanctioned the government's theory. Obviously, this trend, which is not new, is concerning because it really fails to provide individuals and entities with adequate notice that their conduct might be subject to criminal liability. And in addition, of course, it threatens to take the power to define the scope of criminal law and place it at a level certainly never intended by the Founding Fathers, but that's far more removed from the political processes that our Constitution says are to be trusted to make those decisions. There are many different statutes, and I'm not going to cover them all that fall into this category. I'm going to talk about just one here, but there are certainly areas like FIREA, the use of the Travel Act, the Honest Services Fraud Statute, and others where this dynamic exists. I'm going to turn quickly to something that no one, I assume, is in favor of: unlawful insider trading. I'm certainly not. I never was as a prosecutor. But this provides a real clear example of regulation through enforcement. And basically, the law in that area has evolved pretty episodically and unpredictably on an enforcement case-by-case basis between the SEC and the Department of Justice. If you go read 10B and the SEC's 10b-5 statute, and now more recently 18 U.S.C. 1348, which is the securities fraud statute, the legislation, those statutes and the regulation do not talk about insider trading at all. The terms don't exist, and they don't articulate in any way what the government must prove to establish a violation. Yet, obviously, we know people are routinely prosecuted for insider trading violations, and there's lots of case law that's developed and lots of thoughts on the subject. The Title 15 simply just says, it shall be unlawful to use, employ, in connection with the purchase or sale of any security, any manipulative or deceptive device or contrivance in contravention of such rules and regulations. And the 10b-5 rule says to employ any device, scheme, or artifice to defraud or engage in any act, practice, or course of business which would operate as a fraud or deceit upon any person. Well, obviously, making use of information that you received from some other person to make a decision to buy stock, it's hard to see that really fits neatly and squarely within this language. But obviously, we know routinely that theories are pressed on this. And the SEC for years has relied on individual enforcement actions and the judiciary to develop the various liability theories, such as who is an insider, tipper-tippee liability, and various misappropriations theories, all of which really are not directly easily read from the statute. And the Supreme Court from time to time has touched the issue. But once again, it raises questions not about the underlying policy norm about whether we ought to have somebody shouldn't be able to take information, material inside information, and trade on it, but what is the source on which the government is authorized to act? And so I offer that as just one of many examples. And what I would say as we're thinking about the Justice Department more broadly is, as the department has taken some steps early in this administration to talk about prohibitions against relying on guidance and looking at ways to make sure that the exercise of prosecutorial discretion is being done wisely at the line level across the board. And I would suggest that one of the other areas that needs to be examined and scrutinized is where there are areas where the government is reaching or going beyond its statutory or regulatory authority, or arguably so, having a serious discussion about what to do about that that is obviously consistent with making sure that the department keeps us safe, but also ensures order to liberty.
Thank you. Lee?
Thanks. Following that, I was going to talk about a related topic, to overcriminalization, which is the department pressing various issues further than they should go, or the fear that they might. And the first is extraterritoriality. The U.S. has a terrible reputation internationally for applying its law beyond its borders and to other people's citizens. The Economist magazine earlier this year wrote, facing little scrutiny, prosecutors have applied ever more expansive interpretations of what counts as the sort of link to America that makes an alleged crime punishable there. Indirect contact with foreign banks with branches in America, or using Gmail, now seems to be enough. Imagine if China fined Amazon $5 billion and jailed its executives for conducting business in Africa that did not break American law but did offend Chinese rules and was discussed on WeChat. Now that may go a little far, but it actually sums up the problem pretty well. Because while the United States government, of course, is pretty immune to retaliation by other countries in this area, its citizens and its entities are not. Now, we got here over a long period of time, of course, and Congress has, for a very long time, passed statutes with extraterritorial effect. Under international law, there are at least 5 bases of recognized jurisdiction authority to pass such laws. Territorial, which is the basis of most criminal law, certainly. Nationality, which means you can regulate the conduct of your nationals pretty much anywhere in the world. And Congress, of course, has done that on some occasions. Something called passive personality, which really just means protecting your nationals, passing laws that protect your nationals anywhere in the world. Protective jurisdiction, which means protecting the sovereign interests, not policy interests, of the state. And, of course, universal jurisdiction, which war crimes, privacy, and so forth. Now, of course, the U.S. Is a sovereign, can depart from international law, as sovereigns do occasionally do. But very early on, the Supreme Court decided that it would not assume Congress was trying to do that unless Congress was specific about it. And again, I love the names of these early cases. Murray versus Schooner, Charming Betsy, the Charming Betsy. It adopted a rule that said an act of Congress ought never to be construed to violate the law of nations if any other possible construction remains. Pretty good rule. Over time, that turned into basically an effective presumption against extraterritoriality effect. But in the latter part of the last century, in the early part of this, that was under pressure, and the Supreme Court basically stepped in and established, or attempted to establish, some bright lines about how we deal with whether a statute is applied extraterritorial or not. And in cases you've obviously heard of, Morrison versus National Australian Bank, Kayabel versus Royal Dutch Petroleum, and Nabisco, or RJR Nabisco versus European Community, the court came up with basically a presumption that says, unless Congress says specifically this is extraterritorial, we will assume it's not. Once we make that assumption, we will look at whatever your facts happen to be and decide whether it really is extraterritorial by trying to figure out what the focus of the statute was and whether you fall within that. Now, the Justice Department, and that now applies in the civil area entirely. The Justice Department, though, continues, or at least our AUSAs, the prosecutors, continue to argue that it does not apply in the criminal side, and continue to cite a 1922 case called United States versus Bowman for that proposition. Now, the court in Bowman did actually use words to that effect, not perhaps as clear as the department argues, but it did say we're not going to apply the presumption to criminal law that are not criminal laws that are not necessarily bound to any particular place. The case actually involved facts that fell well within the traditional bases of extraterritoriality. Americans were the defendants, and it involved a fraud against the U.S. government, and that is generally considered to be one of those sovereign interests that you can protect. So the case actually has been distinguishable all along. The department continues to cite it. Now, there are 5 circuits, or at least panels, at this point, D.C. 9th, 1st, 5th, and 2nd, that have actually applied it on the criminal side. So it may now be that the handwriting is on the wall, but we do have, obviously, a ways to go. And I think it is time for the department to retire Bowman. But that doesn't mean it won't find additional ways to apply U.S. law extraterritorially. And it recently lost such a case in the Second Circuit, United States versus Hoskins, and decided in the Foreign Corrupt Practices Act area, where basically the department tried to prosecute a foreign national who acted on foreign soil under conspiracy and aiding and abetting theory for violating the FCPA. The Second Circuit, which is not squeamish about applying U.S. law extraterritorially, rejected the position, basically saying the FCPA tells us where it is extraterritorial and where it is not, and you cannot use this other theory to apply the law on an extraterritorial basis. And that, I think, is a good example of the department pushing, always pushing. Now, again, fortunately, we haven't seen a mass of U.S. prosecutions or prosecutions of U.S. individuals by other countries, but we are seeing other countries pass extraterritorial provisions. Perhaps, one of them that is currently important is the EU's General Data Protection Regulation. It applies extraterritorially. So far, the member states, which are responsible for enforcement, and many have adopted criminal penalties, have not been overly interested in extraterritorial application, but it is coming. And indeed, one of the first cases that was brought was against a Canadian company, the UK against a Canadian company. And of course, we have companies like Apple and Amazon and Netflix that are currently under investigation. At any rate, I think that is one area where the department needs to take a look, where the AG needs to maybe set some policy that everybody has to follow on when it is a good idea and when it is not, and when it might be in the national interest to do so and when not. That's an area, I think, where the department has already gone too far. An area where I'm very concerned that the department may go too far is the Foreign Agents Registration Act, something that many people never heard of until about 2 years ago, and that is now a topic of discussion here in town quite a bit. There have been, the registrations under that law have doubled, if not tripled, over the last couple of years. Basically, FARA has been around a long time, and it requires anyone who's going to act on behalf of a foreign principal, which is defined very broadly, governments, political parties, corporations, United States expats fall into anyone domiciled overseas as a foreign principal. Anyone acting on their behalf is supposed to register with the Justice Department and make some very, very detailed disclosures. And of course, it is true the law has not been overly well enforced. I think it has been, that has been largely because the FARA unit has not really had the resources to do so. I think they have overall taken a very moderate and reasonable attitude towards the law and applied it at the very core to lobbyists and public relations efforts on behalf of foreign governments. But the statute is very much broader than that. And as I'm sure many of you know, recently the department announced that Brandon von Grack, a recent alum of the Mueller investigation, is now going to head the FARA unit. a little hard to say what that really means, but it certainly suggests that we're now going to be looking at some serious criminal enforcement of the statute. And because of its breadth, I think the department would be well advised to continue its reasonable and measured interpretation of the Act's reach. For example, because I think if they go too far, they're going to get into First Amendment problems very quickly. Now, FARA, of course, has been upheld against constitutional attack in the past, but there is no doubt that it was originally conceived and designed as a means of suppressing and delegitimizing a certain kind of speech. Now, the speech, as it happened, was by Nazis, real ones, who actually worked for Joseph Goebbels, and this was, of course, a real concern, and Congress drew a law that was very broad in order to address this problem in the years leading up to the Second World War. The statute is still with us, and it still covers the very broad activities that it originally did. And just as an example, I mean, everybody sort of realizes, I think, and agrees that a foreign lobbyist on behalf of a foreign government or someone doing public relations for them ought to be registered. And I have no doubt that if that's where the department takes the law, that it will be upheld. I don't think there's any doubt about that. However, the statute also applies anytime anyone for or on behalf of a foreign principal engages in political activity or propaganda activities in the United States. And the thing is, you don't actually have to be working for a foreign principal in order for this to apply to you. You don't need to be paid, unlike the Lobbying Disclosure Act, where you only need to register if you're being paid. FARA does not have that requirement. And it applies, at least according to its text, even if all you have done is received a request from a foreign principal to do some activity. And that is very broad. And just as an example that I've actually dealt with on a couple of occasions, this country is full of organizations, large and small, by ethnic groups, ethnic organizations, Polish American Society, or, there are dozens of them. Those organizations, by and large, tend to be relatively interested in and friendly towards the relevant country of origination. And the embassies here in Washington know that and also understand how very valuable they are come election time or when you're trying to put pressure on somebody. So it is not at all uncommon for there to be significant coordination between these groups and the foreign governments that are involved. And one can easily imagine a situation where ambassador asks one of these groups or one of the people in these groups, we really are interested in this particular bill, and could you weigh in? And they'll probably do it without realizing that that may well make them foreign agents, and doing it not because really the foreign government asked them to, but doing it because they would have done it anyway. And that is what they want and what they believe in. And I think that aspect of this law has never been addressed by the courts. Very few cases have actually been decided. And even then, the department, as in some other areas, had been relatively careful. A lot of the litigation involved trying to force the IRA's bag men to register back in the 1980s. But if they push this law too far, they are going to, I would predict, they're going to have some real trouble in the courts. And one thing to keep in mind, that very broad aspect of the law is not tangential. It was, in fact, in there so Congress could reach the activity it wanted to reach back in the 1930s. So it's not easily severable. So I would rather, I would suggest that they should continue, if they want to do criminal prosecutions, that's fine, but continue with a reasonable and modest interpretation of that statute because it may well be vulnerable if they don't. At any rate, let me stop there.
Thank you, Lee. George?
Thank you, Judge. I hope Judge Randolph will not mind me relaying just a little bit of our conversation when we were enjoying lunch, which he mentioned that he had occasion to reread then Attorney General Jackson's infamous statement in the Great Hall made to a conference or a grouping of United States attorneys many, many years ago, reminding them to exercise their awesome powers to charge individuals with crime with, and I think I'll borrow a phrase that Lee just used in terms of the Farris statute, with reason and restraint. That was good advice then, and it's good advice now. John talked about overcriminalization. I think a lot of us have been talking and writing about overcriminalization, that is the excess use of the criminal law to regulate business activity, commercial activity for 20-some years now. Not sure how much has changed, but one of the things I'm going to talk about substantively just for a couple minutes are some things in terms of enforcement policy that are changing. But before doing that, I want to revisit this issue of prosecutors exercising restraint. John is absolutely right that prosecutors should not be super regulators. Our regulatory regimes in various statutes are full of uncertainties and ambiguities, and Judge Randolph's court spends a substantial amount of its resources determining how to fill those blanks in. That is, of course, a very important function for the judiciary, and particularly the circuit court in Washington, which hears many of these administrative cases, to do. But that's not the job of prosecutors. And when prosecutors start filling in those blanks themselves, they are aggregating to themselves even more awesome power than they had that arises from their general discretion to decide what and whom to charge with criminal offenses. Here's the elephant in the room, the Mueller report. I haven't had much of a chance to look at too much of it, but I did go and look at the obstruction section. And without specific reference to the Mueller report, I'll simply observe that prosecutors should not be aggregating to themselves the power or the authority to do things that undo the results of elections without a great deal of reasonable restraint in terms of their activities. And I'm afraid that many prosecutors have lost perspective on the need to exercise that kind of restraint. When I was a little baby prosecutor in Washington, D.C., and Earl Silbert was the U.S. attorney, I can remember more than one conversation about difficult decisions that turned on, okay, we know we can, but should we? I don't know how often and to what degree prosecutors now are saying, should we? And the should we doesn't just apply to whether or not to charge somebody. It also applies whether or not to investigate. I just finished representing a member of Congress in a case that went on for 4 years, that the investigation itself ended his political career. And that happens more than once. The prosecution of Ted Stevens that had now well-documented prosecutorial shortcomings in it. That, if you recall that prosecution, it was brought right around Labor Day in a year in which he was subject to re-election. I remember at the time, and it had nothing to do with the case, going, what are they doing? This is something we do not do at the Department of Justice. I say all this and want to emphasize and recognize that the vast majority of federal prosecutors who are out there working hard day in and day out, work between the white lines on a regular basis, work hard to reach right judgments, and are to be respected and honored for the work that they do, particularly for terrible compensation relative to the private sector. But it is important, I think, and I think occasions like an opportunity to read and consider this report, which of course is now going to fall into the political machine and take on all sorts of purposes and meanings that have nothing to do with what I'm talking about. But I think thoughtful people like yourselves, thoughtful organizations like the Federalist Society ought to take this and really think about what's necessary to help prosecutors put the prosecution function in a proper perspective. That being said, I did want to talk about some things that I think are good news at the Justice Department that have occurred under this administration and that you will never hear about on Morning Joe. There's been a number of changes in enforcement policy that I really think are genuine and legitimate and important efforts to bring some increased rationality, particularly in the white-collar context. Back in November of 17, the corporate enforcement policy was announced as something that superseded the so-called FCPA pilot program. I don't want to get down into the weeds on enforcement policy, but basically the pilot program was an idea that we're going to consider the idea of rewarding corporations that do their own internal due diligence, self-policing, make voluntary disclosures, and when they discover problems, disclose them and undertake remedial actions. I argued for years and a couple of times in congressional testimony in the context of international mergers and acquisitions that U.S. company goes out, buys an overseas company not previously subject to the Foreign Corrupt Practices Act, does due diligence, doesn't find any problems, but afterwards, in actually running the company and having a decent compliance program, discovers that the company is now undertaking actions that are issues and potential violations of the FCPA. The theory that I tried to, and others tried to put forward was, okay, let's regularize this. If a U.S. company makes an overseas acquisition in that situation and does a post-acquisition deep dive into the work of that company from a compliance perspective and finds a problem and brings it forward and tells the government about it, and remediates the conduct in issue, there should be a presumption against a criminal resolution or a prosecution of that company. Why? Because that serves the objectives of the Foreign Corrupt Practices Act, which is to level the playing field into one that is not corrupt on an international basis so that American companies can successfully compete on the basis of the value of their goods and services rather than whether they pay the biggest bribe. That's what the act was supposed to do. Too often, the act became a gotcha, and in the particular set of circumstances I'm talking about, it was often used as a gotcha, and that policy has now evolved, and the corporate enforcement policy that was put into place was meant to reward and incentivize companies to do exactly what I described by putting in place a presumption against a criminal disposition if a company undertakes all those steps. Now, there's always a, except in certain circumstances kind of case, and that's fine. They should make it automatic. It makes sense to make a reservation for some truly outlier or unusual situation. In March of 2018, the department expanded that by saying that they were now going to use the corporate enforcement policy as non-binding guidance in cases outside the context of the Foreign Corrupt Practices Act. That is, in other words, more broadly in a number of other types of white-collar cases. And then in May of 2018, the Deputy Attorney General announced what he called a coordinated resolution policy, but which has become more widely known as the anti-piling on policy. What this involves is, whenever there's something, particularly some kind of an occurrence that gets a lot of attention, with disclaimers that I am involved in this, but let's take Volkswagen and the diesel, so-called Dieselgate situation. Companies get subject to investigations coming at them from many different agencies in many different directions, including diverse federal agencies. One of the reasons agencies open investigations in circumstances like that is because they want a piece of the action when the case is resolved. So everybody gets their name, and in the press release, everybody gets a little bit of money, and when they go up to their appropriators to seek yet an even larger enforcement resources, they can say, look what we did here. Mr. Rosenstein's anti-piling on policy is meant to bring some semblance of more rationality to the resolution of cases in those circumstances, and it is a good policy, and it's workable. Also in May of 2018, there was a clarification of the so-called Phillip factors, referring to former Deputy Attorney General Mark Phillip. By the way, if you're going to be Deputy Attorney General, and some of you are young people here someday and you want to do it, you got to get your name on a memo, the Phillip memo, the Holder memo, and so forth. If you don't, you're an utter failure. Rosenstein, in a memo, announced the clarification of the corporate compliance aspect of Mark Phillip's prior policy. And is basically, again, a very smart and practical change in policy. And it basically said, look, when it comes to evaluating a company's compliance program for purposes of what kind of a resolution of a violation is appropriate, we now recognize that one size doesn't fit all. That different size companies with different levels of operations need to have different types of compliance programs. In July of 2018, in a speech given by Deputy Assistant Attorney General Matt Miner, the Justice Department clarified that the corporate enforcement policy, which I was referring to earlier, will also be applied specifically to mergers and acquisitions that uncover potential FCPA violations. So they took that, what was initially a pilot program, expanded it to other white-collar things, and then brought it specifically to bear on the set of circumstances I was talking about before in terms of overseas acquisitions. Let me tell you why that's important and why it fits the President's deregulatory agenda. I can tell you as a real factual matter, I have sat in meetings with corporate executives of Fortune 50 companies who were considering, call it a $30, $40, $50, $60 million acquisition or a deal in a foreign country. And first the accountants find something, and it gets turned over to the lawyers, and the lawyers go, oh, well, it could be a violation. It might not be, but it could be a violation. Because you can never really get a solid answer to those things unless you fully investigate them. So if you're sitting there as a CFO, general counsel, CEO, you go, you know what? I'm not interested in a $100 million risk for a $30 million deal. Now, maybe I'm exaggerating the risk a little bit, but I'm not even interested in a $30 million risk for a $30 million deal. That's not why we do business. And so what is the result of that kind of decision-making? It means that American companies are put at a disadvantage in terms of being risk-taking and applying their entrepreneurial bent to an overseas venture. So bringing some sense that says, you know, instead of making that decision, you know what we'll do? We'll make the acquisition. We'll write some stuff into the deal that hopefully maybe we get the sellers to pay for the problem if we find out it's really there. But we'll dive into that after we get it because we know we can go to the Justice Department and we're not going to get prosecuted if we do the right thing and when finding something. So those are important changes. Just a couple other quick things. In October of 2018, Assistant Attorney General Brian Benjakowski, runs the criminal division now, issued new guidance concerning the selection of corporate monitors. You know, there's been a lot of controversy about, the use of monitors, how they're selected. They cost ungodly amounts of money. I know of one monitor, a person who shall go unnamed, but whose name is prominent, that actually led to the firing of a very good general counsel of a company because he got crossways with the monitor and the monitor's view and so forth. I mean, the monitor tail should not wag the corporate management dog. And the policies that Brian has put in place are designed to change that. And then finally, in November of 2018, Deputy Attorney General Rosenstein made some changes to the so-called individual accountability policy, better known as the Yates Memo. The Yates Memo said to prosecutors, you can't close, this is, again, the Yates Memo, former Deputy Attorney General Sally Yates, she got her name on a memo. She got her name on some other things too. But her policy basically said to prosecutors out in the field, you cannot close a criminal investigation that involves business crime and so forth unless the conduct of every individual who might have had anything to do with the wrongdoing has been accounted for. And what that led to is it's much easier to get a corporation to agree to a resolution on a set of facts and bring a case to closure than it is to investigate to the point where you make decisions about whether or not individuals should be prosecuted. There's a whole host of reasons for that. We could spend hours doing it, but I'm sure many people here through their own experience recognize that there's a big difference between getting a case from a prosecutor's point of view, getting a case to the point where a corporation will say, okay, uncle, you know, what's this gonna cost us, and bring the case to resolution, than it is getting to the point where you can make substantive decisions about the liability of individuals. So the Yates Memo had the potential effect of bringing that whole thing to a halt and really not advancing the department's interests. So what Rod did was kind of strike a balance, and he didn't abandon the Yates Memo, but they made a really good effort to bring some greater sense of rationality to how it should be applied. And with that, Judge, I'll stop.
Thank you, George. Scott?
Thank you. It's great to be around with so many friends here. I'm going to briefly talk about the state perspective on the criminal side, and then I'd like to spend the bulk of my time talking about the civil docket. I think as we hear some of the comments about the breadth of federal criminal law and prosecutions, it has to be pointed out that that runs the risk of crowding out prosecutions from the state perspective, that when you're taking the same operative set of facts and you have a federal prosecution over something now, well, state prosecutors are not going to be targeting their resources in prosecuting those types of cases, and especially if the federal government could prosecute under one of these federal statutes, but then decides, we're not going to. Well, state prosecutors arguably are even more taxed as far as the resources go than federal prosecutors. And so then the reliance not only on when the federal prosecutions do happen, but when they don't happen, I believe is alive and well. And also you're talking about some of the accountability that there are with prosecutors. At least in Texas, I think many other states, county district attorneys are elected, and when prosecutors and prosecution decisions happen at that more localized level, that is federalism in action. That if you don't like what a local prosecutor is doing, there's accountability, and there are additional mechanisms than we see when you have a massive federal operation based in D.C., although there are obviously tons of hardworking and very well-meaning prosecutors that are AUSAs throughout this country that are doing hard work and the best they can. But these are the limitations and the incentive structures that are set up when you end up in a system with the breadth of federal criminal laws that we have today. So, briefly what I'll say about the criminal docket. On the civil docket, the biggest priority that the Department of Justice has had to face in the last 2 years is simply the onslaught of lawsuits blocking what the administration is trying to do. And before I get into some of the weeds of this, it's important to understand these statistics, because everybody wanted to say that, oh, Texas in the Obama years was always suing the administration and they were so bad, and why did they keep bringing all these lawsuits? Well, in the 8 years of the Obama administration, Republican state attorneys general sued the administration 46 times. So in 8 years, 46 times. In 2017 alone, the first year of the Trump administration, Democratic attorneys general sued the administration 35 times. Fast forward a couple years. The Trump administration has been sued at an unprecedented rate. More suits have been brought by states in the first 2 years of the Trump administration than either President Obama or President George W. Bush's entire 8 years. So what the department is facing on the civil side is lawsuit after lawsuit that is trying to gum up a lot of the regulatory changes that the administration is rightfully trying to make. And I mean, even think about this. There are still a series of Obama-era regulatory cases that are still pending. Part of the reason they're pending is because as soon as the administration tried to change those policies, and we're not talking about congressional legislation, we're talking about administrative actions, we're talking about regulatory actions. And it had been thought that when a new administration comes in, as long as they provide a rational explanation for what they're doing, that they could change regulatory actions. But in this series of cases, you could go to EPA Clean Power Plan, obviously the DAPA litigation, there's the persuader rule, there's just pretty much every big agency has one signature Obama-era rule that is probably still being litigated. And when the administration went to change those rules, to rescind those rules, or to replace those rules, they met with litigation brought by Democratic state attorneys general to block the change of the regulatory policy. And this level of litigation really is unprecedented, and it really does raise the question, is this just going to be the new normal, that every time there's a change in a presidential administration, you're going to get state attorneys general from one party or the other that are opposing the president to then come pile on and try to block what the new administration's regulatory apparatus is trying to do. I would also submit that the problem is then further compounded by the new novel use of sweeping nationwide injunctions. And having litigated in Texas and asked for a few nationwide injunctions, we were surprised when everyone started citing our victory in the DAPA litigation for the proposition that was the Obama-era deferred action program that would apply to about 4 to 5 million unlawfully present aliens. All of a sudden, the Democratic state attorneys general turn around and we're citing that DAPA precedent, saying, well, if you find a regulatory policy of the federal government unlawful, you just get a nationwide injunction. And that's not what we argued in the DAPA case. We said this is immigration. You can't possibly say someone is unlawfully present in Texas, but they're lawfully present in California. No, this is a federal nationwide decision that has to be made. But the courts right now are grappling with this question of when is it proper to get a nationwide injunction. In some ways, the term's a bit of a misnomer, I think. It's really about how broad can your injunction be in applying to other parties. In Texas, for instance, when the state of Texas is sued in Corpus Christi about its voter ID law, nobody would think that Texas should be saying, oh, we can't get a statewide injunction against our voter ID law. I mean, maybe they should be raising the argument, I don't know. But that's to say, at the end of the day, the Supreme Court's going to have to take, I think, one of these cases pretty soon and provide some clarity to it, and they do have some vehicles to do that. And then the second big set of cases that I talk about falling under this rubric of regulatory changes is clearly the immigration docket. Whether it's sanctuary city defunding, the travel ban, the border wall, DACA, immigration judge reform. Right now, because there's no congressional legislation being passed to reform immigration, you're seeing a lot of these disputes spill over into the courts, largely because of the case that for so long, regulatory agencies, in particular DHS, have had to be making these determinations about what to do under statutes that have been set for some time with clearly new problems that are coming up. And how these various lawsuits play out and the discretion that the executive branch is given, I think judges are mindful, I think we saw this in the travel ban case, that when courts are making precedents here, they're of course not just deciding the case for this particular president. When we were litigating DAPA, we said time and time and time again, of course, you're not making decisions just because President Obama's in office. There will come a time when another individual will be president. And I think it can be really hard sometimes to pull out of a case to understand that there are much bigger principles at issue. And the final thing that I would add is, particularly on the Department of Justice civil docket and side, the fact that the U.S. Solicitor General's office has had to file so many emergency applications for stays at the Supreme Court is a function of all of this litigation. Whether it was the travel ban case or DACA or the census case, the fact that the administration has been having to go to the Supreme Court to request expedited relief that often truly is caused by having all these different lawsuits that are trying to gum up the works and changing all of these regulatory actions. So with that, I'd look forward to the panel's reaction and any questions that you all have.
Thank you. I have a couple comments, and then I'm going to raise a question. And to pick up where Scott left off, there's a lurking problem with I used to teach a course at Georgetown called Injunctions. I don't know that anybody teaches it anymore. But there's Supreme Court law that contributes to the problems that Scott mentioned. And it's law that dates back, I believe, to the 1960s, and I can't remember the name of the case. But anyway, it goes like this, that if an injunction is issued, you must comply with that injunction. And if you violate it, you cannot defend on the basis that the injunction was invalid. So the only choice you have as a subject of an injunction is to get it overturned and then go on with whatever you were doing. You cannot just sit back and say, well, I'm, a nationwide injunction, that's invalid. And I think that whole doctrine is in need of reconsideration. It was really founded and formed during the desegregation litigation, as I said, in the 1960s. George mentioned, I actually have a copy. I want to read a little bit of, this is the famous speech by Robert Jackson, who was the Attorney General at the time and then obviously became on the Supreme Court one of the greatest justices, in my view, was the prosecutor at Nuremberg. Odd that justices were allowed to take leaves of absence to do things like that. To think of the Warren Report as another. But anyway, I'm just going to take a couple little excerpts from this and then raise a question. And this is a meeting in the Great Hall at the Department of Justice, I think it was back in the 1940s when he was Attorney General. And it's a meeting of all the all the U.S. attorneys from around the United States, plus prosecutors within Main Justice. And some of the things that Justice Jackson, or Attorney General Jackson, said is this. He said, "The prosecutor has more control over the life, liberty, and reputation than any other person in America. His discretion is tremendous. He can have citizens investigated," as George pointed out. "And if he's that kind of person, he can have this done to the tune of public statements and veiled or unveiled intimations. The prosecutor can order arrests, present cases to the grand jury in secret session, and on the basis of his one-sided presentation of the facts, he can cause the citizen to be indicted and held for trial. While the prosecutor at his best is one of the most beneficent forces in our society, when he acts from malice or other base motives, he is one of the worst." In looking over this last night, and then George's remarks about the Ted Stevens trial, I was taken back to a period when I was in the Department of Justice, arrived as a Deputy Solicitor General to Robert Bork in 1975, and the Attorney General then was Ed Levy. And one of the things that Ed Levy set out to do, he was the former president of the University of Chicago, dean of the University of Chicago Law School, was to try to build up the morale, the prestige, and the ethics of the Department of Justice, which were at a low point then. Remember John Mitchell and Mardian and Watergate and so on and so forth. And one of the ways that Ed Levy did that was he established a new office in the department called the Office of Professional Responsibility. And that office, it led directly to the exposure of the prosecutorial misconduct in the prosecution of Ted Stevens. There's a book that I highly recommend to you that has this story, plus the story of Enron, and it's called License to Lie by Sidney Powell. It's a very, very powerful book. But the reason that it became exposed, what happened, it was subordination of perjury is basically what happened in the Ted Stevens trial, is that an FBI agent who was on the periphery of that preparation for trial couldn't take it any longer, and after Stevens got convicted, he at least had a place to go. And the place to go was the Office of Professional Responsibility, set up by Ed Levy in the wake of Watergate, and that exposed the prosecutorial misconduct and other, not just subordination of perjury, but other matters that occurred. So my question, I guess, is this: there's been a great deal of turmoil in the Department of Justice. I have no idea of what the morale is there now. Rod Rosenstein is a friend of Lee's and mine, and I think very, very highly of him. I was glad to hear Attorney General Barr praise him. But I really don't know where things stand. And I am concerned, as George pointed out, I'm concerned about the ethics and getting caught up by prosecutors, getting caught up in publicity. And rushing into the lights. And one of the things that really annoys me, and I'm going to get this off my chest, is this so-called perp walk stuff. We saw that in Enron, and we saw it again in the Mueller prosecutions. And people don't realize that there are two kinds of warrants, arrest warrants you can get, and also search warrants. There's a daytime warrant, and there's a nighttime warrant. And it's very, very difficult to get a nighttime warrant. And so But the way that the daytime warrant is defined in the Federal Rules of Criminal Procedure, daytime begins at 6 a.m., even in midwinter. And so it's dark. And it's not a coincidence that the searches that occur, for example, I won't mention the names, but you can put the pieces together, occur at exactly 6 a.m. That's because they're done by a daytime warrant. And I think that ought to be re-examined, because rousing somebody out of bed, and believe it or not, it's such a coincidence. The press is always there with their cameras. How did that happen? We know how it happened. And I think that is deserving of further investigation. So anyway, my question to the panel, all of you are alumni of the same institution that I am, and my wife. If there is a problem, how does one restore the ethical bases and the kind of tradition that the Department of Justice at least had in the years following Watergate.
Yeah, let me take this on briefly and give a few thoughts. A lot of folks are worried about the morale of employees at the Department of Justice, and I think for the most part, when I deal with them on a day-to-day basis, most of them are completely unaffected by the controversies and things that take up so much of the media time and discussions inside Washington, D.C. Most career prosecutors are just too busy, focused on their own work. So I don't have deep, and I certainly talk to plenty of young associates and upcoming lawyers who are deeply desire the opportunity to become assistant United States attorneys. So I don't think we've got some crisis that we're going to suddenly run out of good people willing to serve and willing to do the job, particularly when there's so much opportunity and there's still so much power it's vested in the department, and the opportunity to work on cases and the opportunity to try cases, given that it's so difficult to find a case to try in private practice these days. On the question of ethics, to me, and obviously Attorney General Levy is really venerated still in the department. I know everybody fights to have his portrait in their office when they're a political appointee because he's so well thought of by everyone, and the efforts that he tried to make on the department's behalf. I think one of the problems, of course, is that there is not enough emphasis on a day-to-day basis proactively by leaders within the department to really give prosecutors the license to step back and not do something. When I tried the vascular solutions case and we got an acquittal, as we're moving forward to getting winning in that case, the CEO, who was also on trial at the same time, I represented the company, remarked to me, I've been on the website, and the Attorney General, gives out these awards every year. There's no award for the exercise of good discretion to not investigate or not go after somebody or not prosecute anyone. And so I think, and in most offices, it is much easier to initiate an investigation than it is to write up a declination memo and get the case declined once there's a head of steam. So there's certain institutional norms that stand in the way. So that's first and foremost. Secondly, when it comes to the internal accountability within the department, while Attorney General Levy's solution in the 70s was a great one, there is a lot to be desired and about with regard to accountability now internally when attorneys make errors. U.S. attorneys and attorneys for the government make errors. And I don't mean that necessarily people need to be hung out in effigy or publicly shamed, but rather that when there are errors of judgment that cause harm to citizens, that may not be actionable as a matter of law, there is no means by which that person is held accountable or a means by which others in the department can learn, because of course it's much better to learn the hard lessons at the expense of others than learning them at your own expense. And the Office of OPR, the Office of Professional Responsibility, that does these internal reviews, generally, when it conducts an investigation, does not interview people outside the department. So in the case of the Vascular Solutions case, we complained to the department. We were concerned about certain practices, not because we believed that these prosecutors were necessarily evil, but frankly, they made decisions that I don't think I as U.S. attorney never would have thought was the correct way that something ought to be done. But they never OPR has no authority outside the department. So they never asked anybody outside the department for their opinion. Well, if you don't ask anybody who has a contrary opinion, you tend to get reinforcing behavior, which is that generally it's a pretty kind process to the AUSA. There's tremendous institutional resistance to holding somebody accountable, even internally, and being critical internally. And of course, the Office of the Inspector General does not have authority to do internal investigation over attorneys. That's been a subject of debate for a very, very long time. I know Chairman Grassley in the Senate has wanted that to happen. I know most IGs have wished it to happen, but it's never happened. But I think it's a time and when it ought to be considered seriously, not because good people deserve to be punished, but because all these people owe a duty to the American people, and the American people are owed explanations, and you need a process by which other internally lessons can be learned more effectively than they can be right now.
Thanks, John. Does anybody else want to comment?
Ray, I'll just mention a couple things. There were a couple of changes to how the department deals internally with lawyer misconduct cases that occurred when Janet Reno was the Attorney General and Jamie Gorelick was the deputy, that I think have had a very profound effect. I'm not even sure that either one of them intended this effect, but one of them was that Jamie brought for the first time a very respected career lawyer up into the deputy's office. Is probably when you were there and when I was there, the deputy's office was staffed completely by appointees of the administration in question. There were no career people in the deputy's office. Dave Margolis was the individual that she brought up, and Dave's a very well-respected guy, kind of a guru of the department and a holder of its institutional memory, and a friend, I will say. But Dave was ultimately given the responsibility to take the results of OPR and other internal investigations and make a recommendation to the deputy for the resolution of those cases. And that evolved over time through successive administrations to where Dave really was the decider. And other people have succeeded to those positions. I'm not sure what the situation is exactly right now. Secondly, in that same time frame during the Clinton administration, assistant United States attorneys were afforded rights to appeal any adverse employment decisions to the Merit Systems Protection Board. That has tied those decisions up in knots. Many of you may not know, but assistant U.S. attorneys are in what's called the accepted service. They're not civil service, which meant when I was a U.S. attorney, for example, I could fire an assistant. I couldn't do it for an improper reason, racial animus or something. But I could say, I just think you're not getting the job done, and you have a couple months, move along. And I did do that, and other U.S. attorneys did that. That affords, and my point is, that affords a level of supervisory authority that can be pretty effective in terms of keeping people's actions and activities as prosecutors in line. And I really think the biggest failing that leads to a lot of the problems we have now is a lack of adequate supervision. And I'll give you an example taking off of something that Judge Randolph said. I represented Bill Allen, who was the government's chief witness in the Stevens case, during the period of time that Judge Sullivan, the trial judge, had ordered an investigation by an independent prosecutor, Hank Schulke. And one of the things that happened this is all public, one of the things that happened during the course of that representation was that we sat down with Mr. Schulke, and with him having knowledge of what the government's reports of investigation showed during various interviews of Mr. Allen during the course of the government's investigation. Mr. Allen's attorney during the course of that investigation was a very good lawyer, a former U.S. attorney himself in Alaska, who kept very good notes of those interview sessions. So it was pretty easy for Mr. Schulke to sit there talking to Mr. Allen, and we waived privilege as to his attorney's notes and look at the notes that Mr. Allen made and the reports that the government made of those interviews. Well, lo and behold, there were many instances of exculpatory information that was given by Mr. Allen as recorded in his exculpatory as to the subjects in the case, exculpatory as to Mr. Allen that were in his attorney's notes that did not wind up in government reports and was never disclosed to the defense in that case. Now, how does that happen? Why does somebody on the government side, which included both FBI agents and prosecutors, think they can get away with that? Well, it's because nobody's watching the store, in my view.
Lee, did you have a comment?
I guess my only thought would be that as to, the department's esprit de corps, as to morale, it is very much a leadership kind of thing. I think Bill Barr is very well placed to raise that. He knows the building, he knows the job, he's done it successfully. I very much agree with George and John in terms of the oversight. I mean, I don't think there's a lot of oversight of line attorneys. And there are a lot of them, particularly AUSAs, and that really is needed. In addition, you need to send the message out that we are here to enforce the law, we really care about that, but there are other considerations that do matter.
Scott?
Yeah, just very briefly. I mean, part of this also has to be seen from the lens that Senate Democrats blocked all sorts of high-level DOJ appointees for months, if not longer than a year. I mean, I think we're finally at a place where DOJ is fully staffed up on the political appointee side, but obviously you need political appointees and the leaders in these agencies to actually lead the agencies. And, again, I don't know if this means that every time there's going to be a presidential administration change that this is the new normal or not, but that cannot be good for the department.
Yeah. Well, we'll take questions in the time remaining. I think there's a microphone somewhere. Right here. Can you come up to the microphone so we can hear you?
For Scott, I thought it was very interesting to hear you put numbers to this issue of what I'd call the obstructionist political response to some of the deregulation, which regrettably fits into a narrative of the courts being somewhat complicit or politically engaged in what's going on in the country right now. And I am wondering if you could have any additional facts that you can add to that. For example, like what's the number of these cases that come within the purview of the Ninth Circuit? What's the win-loss ratio, at least at the initial stage of hearing? Anything else you have to say to make the picture? And I might add, I think that whole picture is something that would be of interest to the public, because I was unaware of this other than the high-profile cases.
A lot of the cases are in the Ninth Circuit. It will not surprise you that these cases are not in the Fifth Circuit. Yeah, I mean, another stat, too, and I forget the exact stat, and the headline, I think, was a little misleading, but yeah, a couple weeks ago, it might have been a USA Today article or something else was pointing out how, I don't know if the Trump administration, they've only lost 90% or 80+% of these administrative cases, and then the article went out and got some people to say quotes about how, these agency officials are so careless and these policies are so lawless. I mean, I think what's really going on is you have Administrative Procedure Act review that is supposed to be for arbitrary and capriciousness. Is this irrational? Do you not have a good explanation? And I think a lot of times courts are not necessarily adhering to that. And when you have courts stepping in to override policy decisions, I mean, you do start to get to a situation of what George alluded to before, of undoing elections that way. So, these cases are continuing to be litigated, and the appellate process continues. But I mean, we're also halfway through the administration, and the clock is ticking.
Yes, sir.
Thank you. 20 years ago, I did get an award from the Attorney General for co-authoring what became known as the Holder Memorandum and for chairing the DOJ EPA Voluntary Disclosure Board, which attempted to exercise prosecutorial discretion evenly across the department with environmental cases. The point I'd like to make here, whether in the due diligence context or in the compliance program, to what extent is it required to address cyber liability issues, including software change management, which has been implicated in the Boeing crashes recently, and other corporate compliance programs, to get to that level of detail in how the governance of information security and attendant liability plays out?
I don't know. It's a great question. I don't know what the answer to it is, but it, in terms of how the world functions today, and the example you give is a good one. I'm not sure what level of sophistication has developed on the department side to look at those kinds of questions. But you sparked something with me. It's certainly something in terms of advising clients that needs to be added to the list.
You know, I think one of the areas that you see it, I don't know that you're seeing it so much on, I think it becomes very case-by-case basis on when you're getting really specific technologies like that might be at stake in a particular aircraft, for example, that's not generally across multiple industries. But obviously, the governing standard that usually gets applied right now is a retroactive look through our securities disclosure statutes rather than a baseline statute that says this is a particular norm from a technological standpoint that ought to be applied. In the data, you know, obviously on the data privacy side, we're seeing a lot of efforts being made. Lee was mentioning the GDPR in Europe. California has passed a statute that's something between basically what we have at the federal level and GDPR. And that's being implemented. And frankly, those statutes, because of their extraterritorial effect or because they're in economically powerful places, they are going to de facto drive a lot of the standards when it comes to data privacy issues, for example, and the necessary software and technological approach to preserving and handling data, even here in the United States, even though Congress and we haven't acted in that area, and we're still sort of debating that fine line between right to privacy and sort of the freedom to use information that's been obtained. So I think that the data privacy is the area where you're seeing most of the standardization being attempted, and people are grappling with it.
I would encourage you to look at ISO 27000, which incorporates all legal requirements within a quality management system framework, and related ISO 29000.
Okay, thank you. Yes.
I'd like to look at something very basic and very practical in Washington, D.C. as it relates to the anti-kickback and the criminal liability. Let's assume that we have a population of disabled people, and those people have been granted $125,000 for medical care and care in their homes, and yet staff people within the structure have limited the ability of these people to access those funds. So at the end of the year, the budget year, those funds go back, the kickback, to the very department that blocked the usage of those funds. How are those issues resolved in the courts where you see real-life situations?
I'm not sure I'm familiar with this specific situation you're describing.
Just a simple kickback that happens from school teachers all the way up and down the line of federal money or budgeted money when it's not spent and it's kicked back. What?
Yeah, well, obviously when I think of the term kickback, I think of something different. I think of a bribe as opposed to money being not spent in a government program and therefore is withheld within the particular program. and what happens to that money in terms of how it's carries over to a next budget year. I don't know the answer to that question, actually, to know specifically. I think it's going to depend on the source of the monies and how they've been appropriated as to whether they can be or cannot be carried over, and presumably that's part of what the Office of Management and Budget works with. There are certainly situations, I mean, you raise an important point. There are certainly situations in which programs are designed to provide support to various people. I know we hear about programs involving veterans, for example, and insurance coverage issues where, the Veterans Administration takes an arguably too narrow view of coverage. They're denied, the veteran is not getting the coverage that they want. Obviously, they're not having to pay money to cover claims that they might otherwise have, and that gets litigated and dealt with. And of course, in some out year, if they lose the case, if the VA loses the case or has to reach some settlement at some point in time in a future budgetary year, they have to satisfy a judgment or a settlement amount. I don't know whether
So
that answers
what
your
division
question.
at the Department of Justice addresses these real issues in America?
I don't think that's an issue that really gets addressed by the Department of Justice, ma'am.
What department does address the,
So I would think that in the executive branch, it's going to be each of the respective departments responsible for their own budget, and each of them have sort of administration components that deal with their own budgetary responsibilities, and they usually work very closely with the Office of Management and Budget, which is obviously associated with the White House.
it looks good on paper.
I think we have time for one more question. Yes, sir.
Senator Warren introduced legislation a couple of weeks ago that would make it a federal crime for a corporate executive to negligently fail to prevent the company from violating any federal or state criminal law or any federal or state civil law if the violation would impact more than 1% of the population of any state or the country. Just wanted to get any of the panelists' thoughts on this proposal.
As Clint Eastwood would say, marvelous.
John, obviously, you may be familiar, I'm sure you're familiar with, there is what's known as the Park Doctrine, which provides strict liability for certain offenses. It's a misdemeanor statute. It's most commonly used in the Food and Drug Administration space. And prosecutors will always take the position that federal prosecutors will take the position, we're not in the business of investigating misdemeanors. And that's a good soundbite, but the reality is in cases, it provides essentially leverage in cases where there is a question of whether somebody has acted knowingly and caused whatever violation of the FDA regs has led to essentially, but they've got the leverage of a misdemeanor, strict liability misdemeanor. So it's not unprecedented that in certain public safety environments, there are circumstances in which something less than an intentional intent to commit a crime is required under federal criminal law. I recently had a dialogue with the SG of England and Wales, and he was asking about a statute kind of along those lines as they're looking at corporate liability statutes. Should there be some kind of failure to act kind of standard? Now, they were thinking about it in the context of intentionally failing to act, sort of at least some kind of deliberate indifference that rises to the level of knowingly, as I think you'd be familiar as a criminal practitioner. But obviously, getting into the world of negligence, that's generally not a criminal concept, and I hope that Professor Warren was really saying that in her role as hyperbole rather than actually as a serious proposal.
Just to keep it bipartisan, some years ago, the late Senator Arlen Specter introduced legislation that would have basically criminalized a negligence standard in connection with product liability. You know, if you run a company that makes a product that does bad things, you can be criminally prosecuted. That went nowhere, and I hope Senator Warren's bill will enjoy a similar treatment.
Thank you very much.